All right, so we're going to get ready to go over the instructions that the judge gave to the jury that they're supposed to follow in order to come up with a verdict. You know, we having this problem with jury 25, and these are the instructions that he seems to have a problem with, that he can't follow, that he wants to make up his own rules that we possibly are getting hung up over, that we might just end up in a mistrial if this person is not removed and he don't bow down and follow the law, sir. Let's go ahead and read these instructions, because I'm trying to figure out what part of these instructions do you not or cannot or won't not or will not follow. But okay, y'all, let me digress just a little bit, because this is really ticking me off a little bit. Okay, so let's talk about some of the rules that he act like he don't want to follow. Okay, so here we go. So judge says, all rise. Jury enters. Right? Now we're talking to the judge, and basically this is the judge talking to the jury, giving the instructions. So he goes, I'll read you the charge. It's long, but I'll try to make it interesting. You have now heard all of the evidence in this case, as well as the final arguments of the parties. I will instruct you on the law. Give it to you. So he's basically saying, I'm going to instruct you on how the law works as I'm giving you the rules of the law, so that way you can have guidelines to follow when coming up with your verdict, or your, once y'all go into that deliberation room. So basically he goes, the evidence is the testimony, the answers, and the exhibits. Arguments are not evidence. So while they're going, each person put their own little spin on it, your argument is not evidence, sir. We got to stick with facts, okay? Okay. You are the sole and exclusive arbitrators of the facts, meaning you are the ones who have to really look through all the fluff and the buffoonery and figure out what is true and what isn't. You're the arbitrators now. Okay, let's just keep that in mind. What is a reasonable doubt? This is the question. What is a reasonable doubt? It's based on your common sense after carefully weighing all the evidence. So basically he's just telling him, you know, what is the reasonable doubt? Well, the reasonable doubt is once you look at all the evidence, not arguments, just facts, just evidence presented, not how they presented to you in their argument, but what we actually saw, what was actually told to you, and what was actually proven. You have to use common sense. Well, here's the problem, Judge. Some people ain't got darn common sense. God gave rock. So because of that, we might have some issues going on here. Hence, Juror 25. Okay, now, so what basically he's saying now, he says, you just weigh each witness' credibility, the truth and importance of testimony. Size him or her up and down. You know, you size them however you can. You look up in and you say, I wonder, can we believe you or not? Or are you just lying for your own ill will in this case? Basically, that's what you're saying. So you got to say whether or not they're lying or they're telling the truth, right? You must decide. Sean Combs has been formally charged in an indictment, and an indictment is not evidence. Count one. Let's go over this. So charges from 2004 to 2024, a racketeering enterprise. Count two. From 2009 to 2018, a sex trafficking, oh God, they cut me up. Sex trafficking of Cassandra Ventura. Count three. From 2009 to 2018, transporting individuals, including but not limited to Ventura, for purposes of prostitution. There was someone who asked me a question. What is he guilty of? Well, these charges. Can we not see them now? Count four. Uno, dos, tres, cuatro. Yes, let's go. Okay, so count four. From 2019 to 2024, trafficking of Jane. Count five. Cinco. Count five. From 2019 to 2024, transporting individuals, including but not limited to Jane, for purpose of prostitution. Each count is separate. Separate counts. 5 counts so far. For attempt, the U.S. must show intent and substantially steps taken. Mere intentions does not amount to attempt. So just because they intended to do something don't necessarily mean that they could hold them in attempt of. Aiding and abetting. Normally doing some act to aid or encourage a crime to be committed. So aiding and abetting is you know that's what's getting ready to happen. And you just overlooking the fact that this stuff that's happening is actually illegal and you should not be doing it. So instead of you saying, I ain't got time to be getting locked down, I ain't gonna do this. You just like, okay, it's just puffy, so we gotta get it done. You know, we just SEAL Team 6. I will never get over that part. For RICO, the U.S. must prove that from 2004 to 2024, so we only need 10 years, but here we got 20. Oh God, isn't it just... There was an agreement between two or individuals of a racketeering enterprise that impacted interstate commerce, but that the defendant joined and committed at least 2 predicated acts, meaning out of all the charges they're trying to charge him from, like I said, they only need 2. Unos, dos, not tres, but dos. Okay, for those that don't see Spanish, 1 or 2, not 3, but 2. 1, 2, 1, 2, not 3. Okay, so 2. Let me get back to it. The reading. I'm just being silly at this point. Okay. The U.S. must prove a mutual understanding to cooperate. So they must prove a mutual understanding to cooperate. You must infer its evidence from the circumstances of the case. Oh, one of my favorite sayings. Actions may speak louder than words. You must consider the acts of all of those you find participated in these crimes. Now, if you find that the Combs enterprise existed, you must find whether it continued in a substantial similar form from 2004 to 2024. The people can change. As to the defendant being a member, he had to know of the extent of the enterprise. So basically saying that the enterprise, Comb Enterprise, Bad Boy for Life, Puffy Entertainment, whatever other reveal, whatever company he had at the time, if he was utilizing this company, that it had to exist between 2004 to 2024, and that the defendant had to know that these crimes exist. Well, of course he knows these crimes exist. They're named after him. So that's a slam dunk. Whoosh. 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 Right, so I always told you, RICO don't have to be an illegal organization. It literally can be a real organization, a legit organization, and it don't even have to start off as a illegal organization. It just has to be illegal activities happening within the organization. Here we go. All right, let me get back. I know I can kind of get it. I can kind of get into this stuff, but okay. The U.S. alleges 8 predicate crimes, and they're gonna list their 8. Okay, there is kidnapping, arson, bribery, witness tampering, forced labor, sex trafficking, transportation of prostitution, Intent to distribute narcotics. See all those charges? I had a list going on one of my other videos, and I ain't list all of them, right? Again, although there's 8 they're talking about, only 2 needs to be proven for facts. So for all y'all that thought they dropped charges they didn't drop charges. They dropped attempted charges because it was proven he did this. Okay, so for all those out there informing people about charges have been dropped, boom, they're gone. Our boy is completely innocent. He's innocent. Nah, you need to wake up, because like he said, you got to use common sense here. And some people on this earth act like they ain't got common sense that God gave a rock. So let's continue. The U.S. has to prove 2 offenses occurred within 10 years. Remember what I told y'all? So for those that are telling me I need to learn how to read the room, well, you need to understand how the law works. And maybe you should read the room yourself, because the ad is written on the wall, and it's written all over his face, and clearly it's written all over his family too. We know I love the Lord too, so we must pray about everything. But how can this monster ask for a moment of prayer? Diddy, you better hold God and hearing that prayer and letting it fall on deaf ears, because you ain't sincere. You just putting on a show here, okay? All right, let's get back. I'm sorry, y'all. Let's read. And I shed a tear for that prayer, because I love the Lord, y'all. Don't get me wrong, I love the Lord. But this monster going down. As long as we don't get this hung jury because of Juror 25. I'm gonna keep bringing you up Juror 25, because you don't work my everlasting nerve with this one. Okay. Kidnapping does not occur if the victim consents. So I don't know who around here saying, yes, take me, I'm yours. Okay, I don't know who's saying that, so we got to say it, I guess, but let's use the common sense, y'all. Okay, consent may be withdrawn, right? So here's the thing: if they consent to it, it ain't kidnapping, but if they withdraw it, it is. See how this goes? All right. Arson. So arson under California law means that the conspirator sets the fire or causes the fire willfully or maliciously. Meaning basically, like when in California, if you start a fire anywhere, you could either do it willfully or maliciously or through others, and it still be considered arson. And I continue. So therefore I digress, for the ones that said I didn't know what I was talking about. Here we go. Let's go. Bribery of a witness under California law requires that a conspirator give, paid, or promise to give a bribe to a person giving or about to give information to law enforcement to unlawfully influence it. So basically, just like all bribery, because they're trying to keep it from out of the law. Hence that tape in the hotel room. When he bribed them people, and for $50,000, and it made it $100,000. Here you go, just a little extra for you, right? Because he didn't want it to go to the police office, and he didn't want to get in trouble for his wrongdoing that he had committed, and he did. That's called bribery, y'all. That's what that is. You paying people off to keep their mouth shut, right? Basically, hey. Coincidentally, you still kind of told the police, even though at the time the security guard wasn't a police, but guess what? He's a police officer now, and that's just crazy in itself. I mean, once this get out, how they gonna keep you as, I'm just curious, how they gonna keep you as a police officer, sir, when you around here taking money? I wouldn't trust you, because at this point, I'm looking at you like you a crooked cop. At this point, you don't take anything, sir. Okay, but I digress again. Witness tampering, in violation 18 section 152B 3, it does not matter if the subject of the threat is in fact fearful. So when you threaten somebody, regardless if they're scared or not, if it's a threat, it's a threat, all right? So basically say it with your chest, because regardless of what happened, you're going down. forward in California. Okay, or New York, however you want to say it. A threat is required, basically what I just said, but must be knowing that it is a threat. For forced labor, 18 section 1589A requires use of force or use of force of physical restraints. So forced labor meaning that they have to physically hold them down in order to do the forced labor, and maybe some of those positions that they saw in court could have shown some forceful holding down. Or I don't know, or grabbing people and putting them in the car and making them go back could show forced labor and kidnapping all at the same time if they truly didn't want to go there, but you kind of made them, with Christine Corn when they had that pew pew when it was P. Diddy had a pew pew on his lap. So what the girl supposed to do? Jump out of a moving car? I mean, come on, y'all. A person may withdraw consent and it may become forced labor. Ex-trafficking will have the same definition as in count 2 and count 4. And transportation to engage in prostitution has the same as count 3 and count 5. Now, I'm in transportation, right? And that's my business that I do. And didn't look at transportation in that field. It does break off in a lot of different areas when it comes to transportation. But I guess this one right here, you want to stay away from when it comes to that type of transportation. The next will come the distribution of narcotics, including the long word that you see here, knowingly and intentionally. Distribution means actual transfer, to deliver to another person for possession. Physical custody is not needed. Control is enough. So basically, if I have this order and I give this person, let's say like my hand is the person, and I just simply give it to them and it's under their possession, it was transferred from one person to the next. So Brandon Paul, you are caught up in distribution of illegal drugs, no matter how small they are. Now, they can't say that you was distributing them with the purpose of trying to sell them because the amount probably was so small, but the transfer of distribution from one person to the next happened. Okay. Y'all see how easy it is to prove RICO now that you're starting to see it for what it is? To deliver to another person for possession. Physical custody is not needed. Control is enough. Okay, so RICO has a 5-year statute of limitation. You must find that it continued from 2000, at least from 2019. If you find that the government you must find that it continued past 2019. If you find that the government had not provided this beyond a reasonable doubt, just common sense, you must find the defendant not guilty. Right? So without a reasonable doubt, without common sense, this is what is happening. You must find the defendant not guilty. See? And this could be what's going on. I'm not saying this is what's happening with Juror 25, but this is probably it. He's probably on the side of he don't think Diddy is guilty, but by the instructions, if I'm looking at these instructions, then I gotta say he's guilty because basically he did do all this stuff. But to me, I don't feel like he's guilty. And so, that's where you have to learn how to take your feelings out. This is where so many people get confused, because where the law is the law, and you got to stick to the letter of the law. And really, to be honest with you, they got him dead to rights when it comes to this. They really do. But so Juror 25, if he felt like he wasn't guilty, but because of these instructions is leading him to believe he is because of how it's written, then he probably saying, well, I can't agree with this because I don't agree with if he's guilty or not. Well, that's not for you to say if you agree with the law or not. The law is the law and you must follow it. So that's where it comes a case of, are you can't or you won't. Because see, now if you go tell us you won't follow the letter of the law, you do realize that comes with penalties all on its own, right? If you won't do it. Not that you can't because you don't understand, but you won't because you will not. And I would take it as a scientist, you're a pretty smart guy. Let's not do this. So let's continue. On X trafficking, counts 2 and count 4, dos, cuatro, 2, 4. Transport means to take or convey from one place to another. Now we're talking about actually driving. We don't mean exportating from one side to the next. We ain't X-Men up in here and there, poosh, somewhere else. No, we mean that they just literally driving them from one place to the next. Not that they poof there, because maybe that's what some people are thinking as to why this is not X trafficking. Is come on, y'all. Let's use this. Let's use this. Reckless regards satisfied the statute. The deliberate closing of the eyes. You must be unanimous at least one specific instant of X trafficking, basically meaning you cannot just recklessly make the decision that you're not going to look at it because of that, because of how you feel. This is the part you got to take your feelings out of it. You have to look at the statutes and the statutes alone. And that's why even though we don't know exactly what is going on inside that jury room base other than the notes, and they are not even allowed to tell the judge what it is exactly, it leads me to believe, based off of reading these jury instructions that was given, that's probably what's going on with him. Not that he don't know how to or don't understand. He just simply don't agree with what the judge gave him. So, yeah, you got to push that to the side, bro. You got to push that to the side. But see, me personally, I think they just need to get rid of him, start with somebody else, because he done made that. Once you know something, it's hard to get that out of your mind. And that's going to play even if they found him guilty, because then you're going to be clueless as to what was it going on. Like, were you biased when you walked in there? And so it will make an appeal all the more great. So that's why I say just get the man up out of here. You have to be unanimous when it comes to this. On counts 3 and count 5, knowingly transporting or arranging of the transportation an individual for the purpose of prostitution. When I was driving people around, even in the cab world, even in the Uber world, Lyft world, as well as my own personal business, they tell you to look out for that. And sometimes you could kind of see clues that something just ain't right. Like the way the person act, how the demeaning activity is with them. When they're transporting, people seem to be nervous. So, and I know I've had some people in my car at times, and I'll be like, "Are you okay? Is all right? Everything all right?" Just basically off of the way they're acting, because, we're trained, if you take your job seriously, to look for these things that are happening. So knowingly transport. And then here's the thing. If you knowingly transport somebody that that's what they're going to do, you just as guilty as they is. So baby, you couldn't get in my car, because if I thought something, then I'm gonna ask you if I have an inkling that maybe, I'm gonna let it be known to the law. I had somebody in my car, I'm not sure what was going on, but you probably want to go check on that. And I even had some incidents like that where I had to call the cops, because that was my feeling. That's what I thought, to check it out. And actually one of them did turn up to be where I don't know if it was more so X trafficking. This woman was really trying to get away from this man, and he wouldn't let her. Now how far it went, I don't know. But yeah, look, you're not gonna get me caught up in your foolishness and be up in my car doing some stuff. I don't even put people out of my car because of what they look. You gotta go, and if I felt like I couldn't do it the right way, I will pull up next to a police officer. Can you get him out my car? Why? And I tell them why I thought so. Okay, now you deal with that. I'm gone. I ain't got time for this. You are not gonna get me caught up in your foolishness. So don't get in my car with that mess if you don't want to get caught out. So, like I said, for the one who talking about, well, if this was your brother, sister, baby, obviously you don't know me, because one thing I tell my family, I love you, I love you, I love you, I love you. Ain't even down to my kids. I love you, but if you're wrong, you're wrong, and I'm not gonna uphold your wrong. And my kids will do the same thing. One of them probably be like, Especially if it come down to her king, her brother. She'll take her phone regardless. But no, the mama, absolutely not. I don't give a darn who you is. You guilty, honey? You guilty. Yeah, that's just it. Okay, I digress. Let's move on. Okay. Buying or arranging a ticket is enough. Prostitution, I think we can say that, does not need to be the main purpose. Prostitution is engaging in actual activities for money or its equivalent. So it doesn't necessarily have to be money. It could just be something that money is worth, like a house or a job or Diddy or anything like that. You must be unanimous on at least one specific act of transportation with intent to engage in prostitution. Now, these escorts like to say, oh, we're not prostitutes, we're just for entertainment purposes. Well, baby, if you got to perform, and I guess they wasn't seeing the video watching you do these non-engaging acts. You was just entertaining, but they saw body parts being intertwined. I'm not really sure. Like, these people trying to get themselves out in trouble before they go down too. It's just crazy, because even though you get immunity, if you get caught lying on the stage, you still can get in trouble. And then if they find something out that they didn't know about, but they found out doing, then they can go after you for those things. So like, people just be trying to watch their behind when they be around here trying to make it sound all extra sweet and nice. Talking about something, we just here for entertainment purposes. Okay. And birds just flapping their wing because they in the air. They ain't flying. They just flapping because they just in the air. Man, whatever. On ventures, the U.S. must prove at least one act occurred in SDNY, the South District of New York. I'm sure that's what I mean, in 8 counties. So they just have to prove one, y'all. Just that one of them had to happen in New York. Judge, he also says, we are in the home stretch, is weighing expert testimony. You should not accept it just because I allow it. So just because an expert say it doesn't necessarily mean that you have to accept it. We're just allowing you to see what the experts say. But the testimony of government officials are not worth of more or less weight than any other witness. So basically, just because they are government officials, don't give them more credibility than a person that isn't. A witness is a witness, and when they take a stand, they're supposed to be telling the truth regardless of what their status is. And especially in a federal case, baby, because if you purge yourself on there, that's federal time. We ain't talking about regular. Once again, we got to remember, we ain't talking about regular time, y'all. We talking about federal time. Who wants to do that mess? Baby, before I sit there and purge myself on the federal, I'll be like, hold up, let me make sure this is right on what I'm saying, because I don't want to say something that's wrong. Like, let me think about this. Hold on, could you repeat that one more time? Like I said, I'm trying to give you the honest to God truth, y'all. I ain't trying to lie. Who gonna lie on that stand, knowingly lie on that stand to go to prison? I'm not trying to do that. Hold on, I'm not really sure. Those words would have been used before I would have said something else, baby. You talking about my freedom for something I did not do, baby? Yeah, go ahead and tell. I'm gonna tell it, but forget that crap. Okay, so witnesses given immunity should be examined with greater can than ordinary witnesses, and that's because if they lie, they're going to prison because they're up on an immunity. It does not behoove them to tell a lie, because if they do, now you're facing charges. Charts and summaries, demonstrations aid are not evidence and will not be available to you in the jury room. So any charts that they use, summaries that they did, demonstration aids that they use, they're not going to let you use those inside the jury room. But basically, if they had immunity for something, then just take it as fact if what they're saying is true, unless it was proven that what they said was a lie. But if it wasn't proven that what they said was a lie, it's fact, and you take it as that. Certain witnesses are permitted to be identified by personas, or basically alias, such as Jane and Mia, because those two people, that's not their name. Their names are actually something else, which both of them are already being identified. So I'm trying to figure out what's going on. They should bear on your evaluation of credibility. So he basically saying, since we're talking about credibility, and since we're talking about being honest, even though they're not technically being honest with not saying their name, you still got to treat them like they're being honest. They're just, incognito as far as their identity. But y'all, this is 2025 where everybody can find out absolutely anything they want with a little bit of information. So this was really crazy on their part. The defendant had no responsibility to testify, and he did not. You must not attach any significance to that. So basically, they're saying that the defendant does not have to prove his innocence or guilt. It's the prosecution where the burden lies. They have to make the case. He doesn't. So simply because he said he doesn't want to testify, you can't hold that against him as he's guilty. That just means he doesn't have to prove his case. That's all that means. And that's all they're saying. Voluntary intoxication may negate the intent requirement of RICO predicates. Uncalled witnesses. You have heard names of people not called as witnesses. Each side had an equal opportunity to call them. Do not speculate or consider this. So just because we did not hear from KK, just that because we did not hear from D-Rock, just because we did not hear from other witnesses that you heard their name come up multiple times, it doesn't mean one thing or the other, because either side could have called them as a witness and neither side chose to. So because of that, you can't hold the fact that KK didn't get on the stand and testify as, oh, they must don't have a case, or KK didn't get on the stand and testify because, oh, he must be guilty. You can't say that because you didn't hear what they said. But whatever you heard about them, take it as fact because it wasn't proved otherwise. So therefore, it is what it is. They had a chance. They had a chance to speak for whoever. And so at this point, the text messages speaks for them. And whatever witnesses say about them, as long as it's not proven to be a lie and it's credible, you have to consider it. So any notes you took are only for you. So basically, it don't matter what Jane Doe number 2 over there wrote down, but whatever you wrote down, that's what you are concerned with. No outside readings. You are to consider only what was presented with the 4 walls of this courtroom. So I don't care what you heard when you go home. I don't care what you saw on YouTube and Instacart. Instagram, TikTok, who am I starting to sound like without them? TikTok and anything else. You are only to pay attention to what you heard inside this courtroom, which to me I think is absolutely crazy, because here's the thing. In most high profile cases like this, they normally question, basically meaning they are putting a hotel away from everybody and they have a close eye on them. The fact that they didn't do this is a little bothersome to me when it comes to this whole case, but okay, let's go. You may not communicate about this case, including on X. Well, here we go. It said it. You cannot communicate about this case, including on X, Instagram, or YouTube. If you see this, tell my deputy. So if the jury see anything on any one of these, or know of anybody that they know for a fact have been persuaded or saw anything from these particular social sites, they're supposed to turn that in and let the deputies know, because now you're not being biased because you already see something other than what you were told on this court. So that's why I said I find it really hard that they didn't keep these people in a hotel away from society, because now you're really putting a lot of faith in these jurors. Because come on, even though they're not going to come out and out themselves, or them people been watching this is to be real. Okay, do not be swayed by bias, meaning you have to stay neutral. You can't have a feeling one way or the other. You just got to look at facts, which is really hard when it comes to a case like this, including explicit bias. These hidden thoughts can impact what we hear and see and how we remember them. You will now retire to consider the case. Each of you must decide the case for himself or herself after deliberating. So no matter what anybody feels, it has to be boiled down to what you think. This is your feeling on the case. It's not based off of what any of the other 11 think. Now, unanimously, y'all have to come up with this decision, but don't let what another person say influence what you want to do, because this has to be your decision based off of simply the facts. I don't want to hear about hearsay from the internet or hearsay what your cousin, mama, brother, sister, cousin, Pookie, and them told you. I'm talking about what you know from this courtroom. And this is why this case is not as cut and dry, not because of the simple fact of RICO. Once you get over the hurdle of truly understanding what RICO and how it is so easy to actually file for a crime of under RICO, then you have to get over the fact of just public opinion, people's opinion, and all that before you can actually just focus in on the facts and look at the facts of this case. And I'm sorry for those that disagree with me, and we'll just have to agree to disagree. But it's been proven, y'all, he is guilty of these crimes. And whether or not you feel like he shouldn't be because of maybe these people agreed to doing this at one point or another, the moment they said no, no means no. And never does no mean yes. It always means no. Right? And I know some of y'all sleep behind is gonna say, well, when they're in the bedroom, they be hollering no, but they really mean yes. Okay, well, that's not what we're talking about. We're talking about physically saying no. When they say no, it's no. And that's all that it is. And that's all that you need to hear. So when you make somebody do something outside of what they want to do, then you're guilty of it. And when has there ever became a time where we could take illegal activities and say that they're legal? And he ain't no pharmacist. He ain't no pharmaceutical person. He ain't the person producing this stuff. So he shouldn't be getting or given any type of drugs that's not prescribed by a pharmacist. So what are we doing here? These things are all illegal. Never have there been a time where anybody could take you and stuff you in a car or threaten you into a vehicle against your will and say, I can do this. Nah, bruh. Nah, sis, you breaking laws. If you do that, you in trouble. If you choose to ignore all the laws that are out there to say you're not supposed to do this, then face the consequences of your action. And you can say all the prayers that you want to. By means, I encourage you to ask for forgiveness in your heart so that way your soul can be saved, but that body need to rot in jail. So that's my opinion on how I feel on the matter, but the facts remains the facts. And the fact shows, let's use a little common sense here, this man is guilty. And hopefully this jury finds him that way. As always, y'all, be your brothers and your sisters' keeper. Keep God first. And toodles.